Hello everyone, and welcome back to the channel. Have you ever wondered what happens if someone copies your YouTube video, steals your brand name, or takes your invention and starts selling it without your permission? How do creators, businesses, artists, musicians, and inventors protect their work? The answer lies in three powerful forms of intellectual property protection: copyright, trademark, and patent. Many beginners get confused between these three terms because they all protect something valuable. But the truth is that they protect completely different things. In today's video, we'll break down copyright, trademark, and patent in the simplest way possible. By the end of this video, you'll clearly understand what copyright is, what trademark is, what patent is, the key differences between them, real-world examples from famous companies, and how they help creators and businesses protect their ideas. So let's get started. What is intellectual property? Before we talk about copyright, trademark, and patent, we need to understand one important term: intellectual property, also known as IP. Intellectual property refers to creations of the human mind. For example, a song, a movie, a book, a logo, a business name, an invention, a software application. These things may not be physical objects, but they still have value. And because they have value, the law provides protection for them. This protection comes in the form of copyright, trademark, and patent. Let's understand each one separately. Part 1. What is copyright? Imagine that you spend months creating a YouTube documentary. You write the script, record footage, edit the video, and finally upload it. Now imagine someone downloads your video and uploads it on their own channel, claiming it as their work. Sounds unfair, right? This is where copyright comes in. Definition: copyright protects original creative works. The moment you create an original work and fix it in a tangible form, copyright protection generally begins automatically in many countries. What copyright protects? Copyright can protect books, articles, music, songs, movies, photographs, paintings, software code, YouTube videos, podcasts. Basically, creative expression. What copyright does not protect? Copyright does not protect facts, ideas, concepts, methods, business systems. For example, you cannot copyright the idea of making a superhero movie, but you can copyright the actual script, characters, dialogues, and scenes you created. Real-life example: when a musician creates a song, copyright protects the lyrics, the melody, the recording. Nobody can legally copy or distribute that song without permission. That's why artists can earn royalties whenever their work is used. Duration: copyright protection usually lasts for many decades, often the creator's lifetime plus additional years depending on the country. Part 2. What is a trademark? Now let's imagine something different. You start a company selling shoes. You create a unique brand name and logo. After years of hard work, people begin recognizing your brand. Then another company appears using a nearly identical name and logo. Customers become confused. Who is the real company? This is where trademark protection becomes important. Definition: a trademark protects brand identifiers. It helps customers identify the source of products or services. What can be trademarked? A trademark can protect brand names, logos, slogans, symbols, product names, sometimes sounds and unique packaging. Famous trademark examples: think about Nike's swoosh logo, Apple's bitten apple logo, McDonald's golden arches, When people see these symbols, they instantly recognize the brand. That's the power of trademarks. Purpose of a trademark. Trademark law is designed to prevent consumer confusion. It ensures that customers know exactly whose product or service they are buying. Example: suppose someone launches a phone company called Apple using a logo that looks almost identical to Apple. Customers could mistakenly believe the company is related to Apple. Trademark law helps stop that. Duration. Unlike copyrights and patents, trademarks can potentially last forever as long as they continue to be used and maintained properly. Part 3. What is a patent? Now let's move to the third category. Imagine you're an inventor. After years of research, you create a revolutionary battery that charges a smartphone in only 5 minutes. This invention could be worth millions or even billions of dollars. But what if competitors simply copied your design? That's where patents come in. Definition: a patent protects inventions. It gives inventors exclusive rights to make, use, and sell their inventions for a limited period. What can be patented? Patents may cover machines, manufacturing processes, chemical formulas, medical devices, technological innovations, engineering solutions, requirements. Generally, an invention must be 1. New. 2. Useful. 3. Non-obvious. If the invention already exists, it usually cannot be patented. Real-life example. When pharmaceutical companies develop new medicines, they often seek patents. The patent gives them exclusive rights for a limited time. This allows them to recover the enormous costs of research and development. Duration. In many countries, patents generally last around 20 years from filing, subject to various requirements. After the patent expires, others can often use the invention freely. Copyright versus trademark versus patent. Now let's compare all three. Copyright protects creative works. Examples: songs, videos, books, movies, software code. Trademark protects brand identity. Examples: logos, brand names, slogans. Patent protects inventions. Examples: machines, technologies, scientific innovations. A simple way to remember: copyright protects creativity. Trademark protects identity. Patent protects innovation. Easy example. Let's say you create a new smartphone company. Different protections apply to different parts. The company name is protected by trademark. The company logo is protected by trademark. The software code can be protected by copyright. The advertising videos can be protected by copyright. A new charging technology inside the phone may be protected by patent. Notice how one business can use all three protections at the same time. Why are these protections important? Without these protections, artists would lose control of their work. Businesses would lose their brand identity. Inventors would lose incentives to innovate. Intellectual property laws encourage creativity, innovation, and economic growth. They reward people for investing time, money, and effort into creating something valuable. Common misconceptions. Let's clear up some myths. Myth 1. I have an idea, so it's copyrighted. Wrong. Ideas alone are generally not protected by copyright. The expression of the idea is protected. Myth 2. A trademark protects my invention. Wrong. Trademarks protect branding, not inventions. Myth 3. Patents last forever. Wrong. Patents usually expire after a limited period. Myth 4. I registered a domain name, so I own the trademark. Wrong. A domain name registration does not automatically grant trademark rights. Final thoughts. So let's do a quick recap. Copyright protects creative works. Trademark protects brands and identities. Patent protects inventions and technological innovations. If you are a creator, entrepreneur, business owner, artist, software developer, inventor, or content creator, understanding these three concepts is extremely important. Because in today's digital world, ideas have value, creativity has value, and innovation has value. And protecting that value can make the difference between success and losing your hard work to copycats. If you found this video helpful, don't forget to like, subscribe, and share it with someone who wants to understand intellectual property in a simple way. Thanks for watching, and I'll see you in the next video.